Thank you very much. So I would like to be very short because this is a very complex topic. And actually my role that I would like to play in this online conference is to speak a little bit about the French way of reception of international and EU law. I was listening for the conference from the morning, and it was very enriching, all the different presentations. And also I would like to thank, of course, the organizers for associating me. And it would be maybe a little bit different what I would like to present today. However, I think it's interesting to see the example of bigger states, or for the EU law founding member states. As you can see that the same problem, the same issues that we are discussing from the beginning of this conference were raised in those countries as well. However, according to an organic or a more diplomatic development, different kind of solution were found for the topic. First, I wanted to start, but I will be very short on it, and a little bit of a historical overview, because I think it's important to understand that for France, the development of international law was already something that was seen as quite organic for the French Republic, as France participated in a very important way to the development of international public law in the European continent. I have started on the slide with the French Revolution, but even before French Revolution, during absolute monarchy, France was a country that concluded many different international treaties with many different other kingdoms all over Europe, and participated in that way to the development of international public law in the European continent. Actually, during the 19th century and after the First World War, the role of France in diplomacy was very important. And parallelly to this development of international law, France also paid attention to develop its proper structure for the reception of this international law. We could speak a lot about the 19th century development and then the 20th century, but I want to be very precise mostly on the Fifth Republic, as the Fifth Republic finally adopted, as we will see, a very flexible dualist model. So now there is no need to speak about monism and dualism, as my colleague Alexandra explained very well what is the difference. And as we will see, and there is something, as I have mentioned in my title, à la Française, in this way of constitutional provisions about international law, because as we will see, France would like to be seen as a monist country. However, according to the practice, there is a kind of dualism, and we can see that there is a switch sometimes between monism and dualism according to the situation. If there is something important for France, then the reception of international law can be seen as in a monist system, so very automatically. However, if there are willingness for limitation, then this flexible dualist model will be more rigid dualist model. And once again, the whole 19th and especially the beginning of the 20th century was a time of the development of the different notions and concepts that were after use during the Fourth and the Fifth Republic after Second World War. There are one new actor in the Fifth Republic, and that is the Constitutional Council, the so-called Conseil constitutionnel in French. And we will see that Conseil constitutionnel and the Conseil d'État, so the French Council of State, which is the other actor, the Supreme Court for the administrative litigation, the two institutions will work on the reception and will work on the different principles for the reception. So as I've told you, you read in the Constitution of the Fifth French Republic that treaties or agreements duly ratified and approved shall, upon their publication, have an authority superior to that of the status subject for each agreement or treaty to its application by the other party. So that's why we say that there is a kind of a monist approach in the French constitution. As you can see, there is a direct application of the treaties and agreements. However, according to the case law of the States Council, Conseil d'État, we can understand that not only treaties, but also general principles of international law are under some restriction when we would like to apply those. And once again, I don't want to go to details because we don't have time, but I could tell you many different cases where sometimes Conseil d'État says that it's possible for the direct application and we can use general principle of international public law without any hesitation in national legal order. In other cases, for the same principles of international public law, French Conseil d'État will say that there is no way to apply them in different kind of litigations, and all that we can feel that sometimes it's a little bit political. There are some basic conditions, of course, as it is written in the Constitution, ratified or approved, so it should be, of course, properly published as well. And then for the applicability, once again, different other conditions are also developed according to the case law, basically of the Conseil d'État, but also of the Constitutional Council in the Fifth Republic. What is interesting with international law that for France, the regulation of international cooperation by legal instruments is something very important. And not only those high jurisdictions are highlighting many times this importance of the legal background for international cooperation, but also I could find during my researches many different documents from parliamentary commissions, from other advisory bodies of the state, where the development of international law, the development of multilateral cooperation especially, was highlighted as something very important. And it is interesting because on one hand, we have a robust concept of sovereignty in France. For French Republic, the idea of the sovereignty is a key issue. One of the document that I used to my research was a recent report of the Conseil d'État, the French State Council, about sovereignty. I think it was 2 years ago that they have wrote their annual report. They wrote their annual report on the subject of sovereignty, and without hiding the problematic between international cooperation and sovereignty. But as it was discussed precedently with the two other presentations at the beginning of this afternoon, I also would like to, and I see that I only have 6 minutes left, I also would like to speak a little bit about the reception of EU law. Because I think it's very interesting to understand how a founding member state of the European integration was approaching to this new legal order, and how this founding member state, which is an important member state in the European integration, could find solutions to the same questions that we raised about the protection of constitutionalism, about the protection of national constitutional identity in the European integration. It is interesting to say that for Conseil d'État, during 3 decades, the idea of the new legal order of the European integration was something completely unacceptable. I could tell you the different rulings of the Conseil d'État where it went completely against the landmark decisions of the Court of Justice of the European Union, telling that primacy but also direct effect cannot be accepted by the French legal order. openly against from the 60s. The first case where a French State Council accepted first primacy, it was the Niccolo case in 1989, and then the direct effect in another case in 1992. So just the time when already the Maastricht Treaty was under discussion. And the idea of being interested by constitutional law towards European integration arrived only with the Maastricht Treaty. Before Maastricht Treaty, for France, there was no constitutional problem about European integration, as European integration cannot have any impact on French constitutionalism. This was the basic idea. But after Maastricht Treaty, it was important to say something about the reception of the EU law, and actually a very interesting system of control developed during the 3 decades that we have after the entry into force of the Maastricht Treaty. In the 90s, to summarize this development, in the 90s, it was a more timid approach to EU law, and basically it was not the State Council, but the Constitutional Council that said that there are many different obligations towards the French Republic because of European integration. So the idea was not to oppose national constitutionalism to European integration, but to say that all different obligations coming from European integration are obligations also under French Constitution. Actually, they try to do the same that we can see in the case law of the Court of Justice, when the Court of Justice said that the constitutional requirements should be considered under EU law as obligations from EU law. So the French Constitutional Council started to say that all different obligations coming from EU law should be also considered as constitutional obligations for the French Republic, as there is, after Maastricht Treaty, a new provision in French Constitution about European integration. And then it's afterwards, from the beginning of the new century, that we will start to have those different judgments from Conseil Constitutionnel and from Conseil d'État, where we can find some limitation. So first it was Conseil Constitutionnel who started in a case in 2004 and then in another in 2006 to speak about national constitutional identity. Actually, we can see, obviously, they borrowed the notion from the German case law, and they tried to oppose the same concepts, but in a little bit a different way, speaking about fundamental or essential conditions of exercising national sovereignty. And they used this concept in order to say that there can be some limitation and there can be a control of constitutionality, at least for the national implementation of directives. And then Conseil d'État went far away and started to say also at the same time, the first case was the Arcelor case in 2007, started to say at the same time that there should be a kind of balancing. And actually, and I will finish by that because I see that I have only 1 minute left, but actually I think it's a very interesting way to find an equilibrium between European law and national constitutional law. The French Conseil d'État said that if there is a problem of constitutionality when we are applying secondary EU law or even the treaties, then first it should be researched by the national judge whether or not we can find a similar constitutional requirement in the EU law. If we can find a similar constitutional requirement in the EU law, then we can say that we apply the EU law as the Court of Justice asks us to do, but as EU law, we will apply some national constitutional requirements. If there is a hesitation, we cannot decide whether there is something similar in EU law, then we have the preliminary ruling. We can ask the Court of Justice of the European Union to tell us whether or not there is a similar requirement in the EU law. And if there is no similar requirement in the EU law, then, and the French Conseil d'État even recently in 2021 in 2 different cases was very, how to say, clear on that. If there is no requirement in the EU law and we have a problem with a national constitutional requirement, then the act of the European law should be put aside and we have to respect the national constitution. Because, and I will finish with my conclusion, the basic idea is to find a way where we can, maintaining dialogue with the Court of Justice, maintain also the precedence of national constitution in the legal order. And for that, I called it a model of legal diplomacy. The high jurisdictions from France, they tried to influence as much as they could also the court in Luxembourg. So sorry for being so quick on that, but I wanted to tell you what was the most important part, but also I would like to respect the timing. So thank you for your attention.